Realistisch bin ich um 8:30 dort drauf. Wer dann wie zuerst und nachher ist, einfach bitte mit den Kollegen beim ORF ausmachen. Basically, we have the problem that in Europe we do have fundamental rights, but we're not really enforcing them. And that's something that we saw in the US a lot, that US companies said, the Europeans with their data protection stuff are kind of cute, but nothing is ever going to happen. So the interesting thing is really to get these cases up and to get red lines on what is possible. The other thing is really the issue of mass surveillance, and that's not only what the US does, but also within Europe we have a lot of mass surveillance. So this judgment can help here as well to say that these forms of mass surveillance are just too much. And overall, it's also a political sign that just violating other people's privacy has to stop to a certain extent and is not, easily done. The biggest problems we have in Europe is really the lack of enforcement. I think that was also what outraged the judges in this case the most, that the European Commission, who was in charge of the safe harbor decision, which is at the heart of the case here, has tried to fix it for 2 years but didn't really come up with any solutions. And we see that a lot in the privacy field, that there's a lot of looking away from the problems, and there's a lot of ignoring the issues. And that was really what the court has said today as well, that politicians have to take action, have to protect our privacy. And this whole case was only possible because of Edward Snowden and what he uncovered. And that was the thing that ticked me off the most, is that we had European politicians sending angry letters to the US, but no one really took action. Everyone kind of tried to get it under the rug. And that was really the judges now at the European Court of Justice that intervened here and said, no, it's not something you can just dump under the rug. You have to take action and you have to enforce things. Super, bis dann. Bye-bye. And the reason I brought up this case was that you actually have companies that are necessary for surveillance. In this case, we really have a private surveillance by Google's and Facebook's and Apple's, and they all suck up the data afterwards. So we have a private company first gathering the data, and then the government taking this data as a secondary user. And if you get the companies out of that equation, and you can do that as Europe because you have jurisdiction over them, you actually can harm the system to a certain extent. Kann ich später sonst zurückrufen? I talked to Facebook previously. I've heard their statement today that they say it has nothing to do with them, basically, which of course they have to argue somehow. But Facebook is really the issue in this case. But the case was broad in the sense that it applies to all the other big companies as well that engage in mass surveillance. So the message really that the court said today is you cannot engage in mass surveillance in the US and still be complied with fundamental rights in Europe. And that will be an interesting thing, because these companies sit on two chairs. And the US law says you have to do surveillance. European law now says you can't. And this can only be solved on a political level. But Europe now has a certain token to say, if you want to be on our market, you have to play by our rules. Ja, also wie ihr das, im Prinzip mir ist es ganz egal. Ich fahr vom Flughafen sofort zum Königelberg rauf. I think the basic message is that if you have your rights and you should claim them, you just have to make sure that your claim is good and it's not a waste of time. In this case, it was really a very narrowly crafted thing where it hit right the spot where it was reasonable that it goes up. And what we need in the long run is just more enforcement. And it's very likely not the individual person that can do that much, but what we need is collective enforcement, to have NGOs, have organizations that do that for everybody.